Welcome once again to Lehto's Law. Here's Steve Lehto.
Madison sent me notes. Steve, check out this story. It's a big one from Wired magazine. Thomson Reuters wins first major AI copyright case in the U.S. In 2020, Thomson Reuters filed an unprecedented AI copyright lawsuit against the legal AI startup Ross Intelligence. In the complaint, Thomson Reuters claimed the AI firm reproduced materials from its legal research firm, Westlaw. Today, a judge ruled in Thomson Reuters' favor, finding that the company's copyright was indeed infringed by Ross Intelligence's actions. None of Ross's possible defenses hold water. I reject them all, wrote the judge in the opinion. One more time, because this is quite definitive. None of Ross's possible defenses hold water. I reject them all. Now, Thomson Reuters didn't respond immediately, nor did Ross Intelligence, but the generative AI boom has led to a spate of additional legal fights about how AI companies use copyrighted material, as many major AI tools were developed by training on copyrighted works, including books, films, visual artwork, and websites. Right now, there are several dozen lawsuits working their way through the U.S. court system, as well as international challenges going on in China, Canada, the UK, and elsewhere. Now, notably, the judge here ruled in Thomson Reuters' favor on the question of fair use. And a lot of people thought fair use would allow them to do this. The fair use doctrine is a key component of how AI companies are seeking to defend themselves against claims that they used the material illegally. The idea underneath fair use is that sometimes it's legally permissible to use copyrighted material without permission, for example, to create a parody or in a non-commercial research setting or in news production. When determining whether fair use applies, courts use a four-factor test looking for the reason behind the work, the nature of the work, the amount of copyrighted material used, and how that use impacts the market value of the original. Thomson Reuters prevailed on two of the four factors, but the judge described the fourth as the most important and ruled that Ross meant to compete with Westlaw by developing a market substitute. So the point is that if you went into an AI system and asked it about a legal opinion, it might kick back something to you that it had derived from work by Thomson Reuters. Thomson Reuters makes their living by providing the legal information to people who are seeking it. And so if people could go to this other source and find that, yet the material had been gotten from Thomson Reuters, well, you can see why Thomson Reuters might be upset by that. So a spokesperson for Thomson Reuters did eventually get around to responding and applauded the ruling in a statement emailed to Wired. We're pleased that the court granted summary judgment in our favor and concluded that Westlaw's editorial content created and maintained by our attorney editors is protected by copyright and cannot be used without our consent. The copying of our content was not fair use. So some people are already thinking this, that when the government, a court, publishes an opinion, that opinion is in the public domain because it's created by the court. And here's the opinion. So if you want to go read a legal opinion, you can find them all over the internet. But what Thomson Reuters does with Westlaw is they not only publish the opinion, but they publish it with commentary where attorney editors read the opinion and then point out things that they think are important. And that added value is what is so important here, because a company that wants to teach its AI how court opinions read could simply go and find the court opinions and load those in. But by loading in the ones from Thomson Reuters, they're also loading in all the work done by the editors from Thomson Reuters. So even before this ruling, Ross Intelligence had already felt the impact of the litigation. The startup shut down 3 years ago, citing the cost of being in court. In contrast, however, many of the AI companies are still fighting out in court, are financially equipped to weather a big legal fight, and that'd be like OpenAI or Google. Still, the ruling is a blow to AI companies, according to a professor who said if this decision is followed elsewhere, it's really bad for generative AI companies. He believes that the judge's ruling suggests that much of the case law that generative AI companies are citing to argue fair use is irrelevant. Meanwhile, an attorney who's a partner at a law firm that's focusing on intellectual property law agrees that this will complicate AI companies' fair use arguments, although it could vary from plaintiff to plaintiff. It puts a finger on the scale towards holding the fair use doesn't apply. And so keep in mind that this is simply one trial court level opinion. So if somebody files an action in that court, well, that court might say, gee, we've already ruled on this, so we can do this quite quickly. Other courts might rule other ways. And this is, I guarantee you, something that will work its way up. Because you're going to have extremely big, and I'm talking about rich, defendants and plaintiffs, people on both sides of the V, will be well-funded. So you're going to have on one side, like say, Google. On the other side, Thomson Reuters. You're going to have big, big companies that are like, hey, look, we're going to take this to the bitter end because it could be existential. It could be that it can put somebody out of business depending on how this is ruled. And as noted, Ross Intelligence already folded. And they said, this is why. We couldn't afford to fight this anymore. Well, unfortunately, they lost in the end. So the fight didn't work out for them. So again, it is going to go up, and eventually I'd bet money on it. But unfortunately, the time frame is the hard part. But it will be in front of the U.S. Supreme Court somewhere down the road. And they're going to have to rule on what happens if, for instance, to teach the AI about somebody, they take that person's autobiography and feed it into the system, word for word, because that is the basis of another lawsuit I've heard of, where somebody said, I understand they used my autobiography, word for word, and fed it into their system, and that's not why I wrote the book. It wasn't intended for that purpose. So there will be a lot of other arguments made along the way. But here is the interesting one, because the underlying thought being a court opinion, that is public domain. Court opinions are public domain. But Thomson Reuters got those editors who are attorneys who lend a lot of valuable insight. And so I remember this from law school, that when you find an opinion in a law book, it's usually edited to make it shorter and focus on what you want to focus on. But if you went and pulled the opinion from Westlaw, there were head notes. And all these head notes are in there explaining, here's why this is important. Look for this, look for this, look for this. Those head notes all came from editors. And so by putting that in the system, it trained their AI quite differently than if they'd simply put in the public domain opinion and left it at that. So that's the big distinction here. So Madison sent this. Thank you very much. He spells his name with two T's. It's not a Madison female name with a D. But Madison sent this. Thank you very much. From Wired, Thomson Reuters wins first major AI copyright case in the U.S. Questions or comments? Put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Life's too mysterious to take too serious.